So I'm going to bring up Attorney Bob Mannor for Hot Topics.
All right. So this is always how we end the day with an update from last year. And so last year we decided to divide things into the good, the bad, and the ugly. So we're going to do that again. I'm going to ask you to indulge me for a minute here. This is the Mannor Law Group team. And this wouldn't be possible without them. We got some amazing people, so I just kind of want to thank everybody. So if you can appreciate the group over there that's gathering. Some of them went back to the office to get some work done, but they're all gathering here now. So Kelly is one of the other attorneys. If you ever have any questions, you've heard from Melissa. Kelly spoke last year. And there's myself. So one of the things I always offer everybody, and I can't make this open to the general public, but if you have a dilemma of something that's going on and you think that there's some legal concern and you just want a quick answer on something that's related to your work, you're welcome to reach out to us. You can email us or call us. I only offer this to other professionals. I can't open this up to the general public because then I'd go broke. But it is, if there was, we had an issue, somebody came up recently, one of the facilities called us and said, okay, well, the power of attorney is leaving town, and they want to be able to appoint their backup. And is that possible? And we said, yeah, that's a simple answer, and we just kind of gave them that information. Now, some of the time, you might call us with a dilemma, and our answer has to be, yeah, you got to call your corporate attorneys. You got to call, most of the places that you work are going to have an attorney, and sometimes the answer might be, yeah, you got to go to your attorneys. But if it's something simple like that, we're more than happy to be here for you. You can reach out to us. Sometimes the easiest way is to reach out through Lisa or call the office. But that's the crew. We actually have a brand new employee started yesterday. So he's been observing in the back, Gregory Raymond. So he'll be finally another man in the office. I generally don't hire men, apparently, because we've always had female employees, but there's finally going to be one other man in the office, so he's going to be an operations manager, and it's one of those things that we're constantly looking for improvement, right? We're constantly trying to figure out how can we communicate better, how can we do better, and that's what Gregory's expertise has been in, and he's worked with several companies in making sure that they're more efficient and to be able to offer services in a much more clear and a communicative way. So we're really lucky to have him, and we're excited about the future and just trying to get better and better. So I appreciate that. I do want to spend a minute on what happens if you call us. So what to expect when you refer somebody to us. You can call us, or you can have them call us. One of the things that we notice is that it's difficult to call a law office, right? I used to compare it to going to the dentist. So I had a few years back then that I didn't go to the dentist for a while. And then when I finally did call a dentist, I was kind of embarrassed, and I didn't really, I was like, oh, they're going to yell at me because I haven't been to the dentist in 6 years. And so the bottom line is people are nervous to call a lawyer's office, and we try to make it as comfortable and as relaxed as possible to give them, make sure that they are comfortable and that they are able to get their questions answered. But it is one of those things that sometimes if you really think the family needs help, that you call together or that you call them on your behalf or shoot us an email. If you do let us know that you sent somebody our way and they give us permission, we'll follow up with you and let you know what happened. We always are going to try to send them back to the place that sent them to us. So if somebody calls and they said, well, yeah, I heard about you over at this assisted living or that we're going to try to honor that and make sure that they get back to you. We do provide a free screening by phone. And for any kind of estate planning, maybe they just need a new power of attorney. Maybe they do need guardianship. Maybe they need to look at their after-death things like wills and trusts. But we also are going to be advising them with regard to veterans benefits, Medicaid, Medicare, hospice, all of those things. Sometimes they just need advice. Sometimes they need to rearrange things to make sure that they're going to be eligible for those programs. We listen to their story. That's one of the things. when we get to discharge planning, I don't know if, how many of you are involved in discharge planning, but one of the things that we find is that you don't have a lot of time with the family. So we talked about, sometimes we try to provide you guys with tools, and we talked about maybe providing a tool that walks through all the different options that you can do when they're going to be discharged, what's the next step. And the feedback we got was, that's really great, but we just don't have that much time that we can spend with each family like that. And that's a real shame, but we can do that. We can do that. We can actually sit down with them. It's one of the things that we have with Lisa that she's able, that's the point of having an elder care coordinator and the point of having life care plan, is the ability to actually spend some time with the family and figure out some of the nuances that's going to make their quality of life better. So if we can help, we're going to set them an appointment. If we can't help, we're going to try to point them in the right direction to give them a resource that can help. And if they, if you let us know that you put them in our direction, if they give us permission, we will follow up with you. I'll circle back to the challenge I made you guys earlier, that if you haven't had your own planning done, both, of course, I think the most important for most of the folks in the audience is going to be making sure you have your lifetime documents done, okay? What happens if you don't die? A lot of people think about going to a lawyer to talk about what happens when I die. I think more important is what happens when you don't die, what happens when you're alive, what happens if you get sick. And so those are probably more important to say, who's going to make decisions for me? What's going to happen for medical decision making? What about financial? Sometimes we assume that our spouse would have that authority automatically. That's not true. Okay, if there's two names on a deed, can't sell the house, can't do anything with the house without two names. And if one person can't sign, we need a power of attorney or a court order, or access to your retirement accounts. If your spouse's IRA or 401k, you want to be able to access that, but they become incapacitated, you can't access that without a power of attorney or a court order. And so it's something real important. And I did say something like, if you're 18 or older, you probably should have something in place. So even sometimes some of your kids, you might say, okay, they're adults now, maybe we should do that. And so what we do on those types of things is you're welcome to come by. There's a free consultation for that. We have you come in. There's no cost for you to come in and do an analysis to see what it is that you need. And we're also going to, of course, talk about what happens after death. We're going to talk about, a will or a trust or those types of things too. And then you get to decide whether or not you want to get anything in place. And there would obviously be fees for that, but there's no cost for that first meeting to come in and check things out in case you want to get your affairs in order. And like I said, it is important if you're advising other people that they need to do it, it'd be really important for you to have experienced that too. It's, they always say, doctor cure thyself or whatever. No, it's the doctor that doesn't take care of their health. It's the lawyer that doesn't do his own, their own things. And it's the social worker. You're giving advice. You should maybe have an opportunity to go through it yourself so that you see and you've made sure that you protected your own family. The story that it always comes back to is when you get on an airplane, what's the first thing they say in the warning when you get on the airplane? If the oxygen masks come down, you got to secure your own mask before you help others. And that's true. And it's very true. You got to make sure you've got your own affairs in order and your own ducks in a row. So that's just I'll get off my soapbox now. Actually, I won't, because this one's all about being on my soapbox. The hot topics, I like to kind of tell you about the issues of the day. And I actually forgot I have some notes because there are some issues of the day that have just started, in the last few days, there's been some legislation proposed, and I wanted to let you know about some of the legislation here. So, we talked about dividing the update into the good and the bad and the ugly, but I don't like ending on ugly, so I switched it around. We're going to start with the bad, the ugly, and the good. I changed it around because I like to add on a positive note, so we move things around a bit. So let's start off with the bad. So I'm going to have to step down here so I can see the screen a little bit better. Jensen case. So what is the Jensen case and why is that important? Well, I've been talking about this for, 3 or 4 years now, and it seems to be this matter that the nightmare that never goes away. So what am I talking about? It's whenever somebody hires a home health aide, they try to stay in their home. Isn't that what we're supposed to do? Try to stay in our home, try to stay off of Medicaid. But in the Jensen case, Margaret Jensen She didn't have a lot of money. Her spouse had died. And so she wanted to stay off of Medicaid. She wanted to stay out of the nursing home. She wanted to stay in her home. She lived up in Muskegon, had a small home. And so she had a grandchild that would come out and help her out. And so the grandchild would sometimes drive all over the place for her and pick up prescriptions for her, things like that. But the grandchild couldn't do it all the time, so they decided, with the help of the grandchild, they hired a neighbor. And they hired the neighbor, and they paid the neighbor way below market rate. So they paid her less than what you would pay, somebody else for that. But they hired the neighbor, and the neighbor, over a period of about 11 months, got about $18,000. And it was pretty much round-the-clock care. I mean, she was on call anytime and was definitely there 5 or 6 hours a day, pretty much every day, helping out Margaret. And so then eventually she ran out of money, and eventually her care was needed so much that she had to go to a skilled care facility. She applied for Medicaid. This is up in Muskegon, like I said. And she got denied because she had reimbursed her grandchild for his mileage, for his gas expenses, and because she paid that caregiver. She paid the home health aide. And so a local attorney said, that can't be right. Wasn't she doing the right thing? Wasn't she supposed to try to stay off of Medicaid and stay in her own home? And so the local attorney took it to the circuit court, and the circuit court said, yeah, that can't be right. You can't do that. You can't penalize her for doing the responsible thing. And they won. The judge, made them win. Unfortunately, the state decided to appeal that decision. And they appealed it, and they went to the Court of Appeals, and a 3-judge panel on the Court of Appeals decided that they can penalize her for that. And if you read the opinion, that you can tell that they're like, this is bad, we don't think this is a good thing, but that's the way they decided. Now, I would argue very strongly they decided the decision wrong, because the actual rules, the Bridges Eligibility Manual, which is the manual for Medicaid, the Bridges Eligibility Manual said that only had requirements that you had to have a notarized contract if it was a family member. So maybe they should have been able to deny or cause a penalty for the reimbursement to the grandchild, but they certainly shouldn't have caused a penalty because they paid the neighbor to help out, right? But that's not how the Court of Appeals saw it. They sort of misinterpreted it, and Margaret Jensen lost. Well, that was okay, because that's just one case. That's just Margaret. It's awful that happened to Margaret. But the state felt empowered by that, so they went back and they changed the Bridges Eligibility Manual. So they changed the rules to comply with the Jensen case, and so now anytime we hire any home health company, even companies, they say that you have to have a notarized contract or those payments could be considered a transfer or a gift. Okay? This is absurd, right? This is absurd. Why would they even want to? From a public policy standpoint, why would the state even want that? Because this is where they're trying to stay off of Medicaid. It's supposed to stay in the home, give them better quality of life. There's no reason why the state would vindictively try to punish somebody for staying in their home and hiring a home health aide. So here's a couple things on this. The state has been selectively enforcing this rule. One of my friends had a case that this was the situation. They had hired a home health company, and they had spent all this money, and they ran out of money, and then they applied for Medicaid, and so she went through the process of the appeals, and she had this great case. She was ready to try it. She's an excellent lawyer, and she probably would have won if they let it get to the courts, but when it went through the Medicaid process, they said, nope, you lose. She took it up to an attorney, the administrative law judge. They said, you lose, and so she was ready. She said, okay, great, because now I can take it to the courts, and I can prove that this is ridiculous, and I can get this rule overturned by the courts. And so the state said, but we're not going to enforce that. You lose, but we're not going to enforce that in your particular case. So they didn't give her a chance to appeal it, because she probably would have won. So we're trying to address this. We have a new administration in Michigan, and we have a new attorney general in Michigan. And so we're trying to arrange a meeting with the attorney general. We also have a new legislature. And one of our members of the elder law section of Michigan is a newly elected representative. And so we are having, really hoping that this is going to be addressed, because this issue is absurd. And I think anybody on any political side of the aisle would say, no, you shouldn't punish somebody for trying to stay in their own home. You shouldn't punish somebody for trying to stay off of Medicaid. So it's our top priorities I mentioned earlier are the waiver issue, the income limit for waiver and PACE, and then this is our third priority, is getting rid of these care contracts. So we've hired a lobbying firm, our section of State Bar, which I'm on the executive committee for that. We've hired a lobbying firm. I'm going to go with a bunch of my friends and other lawyers to Lansing in a couple of weeks, and we're going to do a lobbying effort and visit our legislators and talk to the director of DHHS is going to be there. And we're pretty optimistic about some of these things, that we seem to have an ear of the administration, and maybe we can get some of these things fixed. All right, my next bad thing here is what I call abusive guardianship. So I want to be very clear. Public guardians are a crucial, important safety valve for our society. There's many, many good public guardians that are honest, hardworking, and boy, what would we do without them, right? If we have somebody that doesn't have family, then somebody needs to make sure that their finances are in order and they're in a safe place and they're where they need to be. What would we do without them? Unfortunately, there's been some abuse. And so this has been in the news in Michigan about self-dealing by public guardians, hiring your friends as public guardians, hiring your daughter, your son, your buddy, and maybe getting kickbacks. I mean, there's been articles in the paper, and I think there was one attorney that got disbarred for this type of thing that was a public guardian, I think in the Lansing area. I like to point out how bad it can get when we talk about this, when we don't have a check on public guardians. So there was an article in the New Yorker magazine, and talked about, the title of the article was How the Elderly Lose Their Rights. And it told the story of Rudy and Rennie North. And Rudy and Rennie North lived just outside of Las Vegas. They had moved there. They were still never diagnosed with dementia. They had some memory issues, as many elderly folks do, but they were getting by for all intents and purposes. They had a daughter that lived 10 minutes away. Doctors had never identified them as being in danger. In fact, no one really had identified them as being in danger. And one day, they're having coffee at their kitchen table. They get a knock on the door. There's actually had a nurse. They were paying a nurse to come by, so they had a nurse. The nurse was there at the time. Knock on the door. This woman named April Parks was at the door with some deputies, and they said, the court has ordered that you're subject to a temporary guardianship. We're going to move you to an assisted living 50 miles away, and you've got about 20 minutes to gather some stuff because we're going to move you today. No notice, never told the daughter, never told Rudy and Rennie, never had a chance to appear before the judge before this happened. Now, it's a temporary guardianship, so that means they have to go back to make it permanent or to extend it. But because it was granted as a temporary, there was no notice whatsoever. And so they didn't know what to do, and so Rudy says, no, this can't be. This is crazy. How could this be? And they said, well, we're going to call the police. Now, if you look at, we were talking about they call it the silent generation, the greatest generation. How do they respond to the police? Are they more likely to be a little freaked out by the idea that they might be arrested? I remember when I was a kid, and we'd have Christmas parties at the house, and one of my sisters was dating a cop, and so he pulled up in his police car, and my mom was mortified that there was a police car out in front of our house. And so that's the generation that we're talking about here, is that she was mortified. They're like, oh, you can't call the police, so they just went. And they went, and they drove them 50 miles away. Now, why isn't there assisted living closer than that? Why that one? Why that assisted living? And then, and then the daughter wasn't even notified. So the daughter stopped by later that day because the daughter was in the habit of coming by pretty much every day. She stopped by later that day. She was worried. She was like, what is going on? They're not here. They're always here. So she went to the clubhouse because they were in a community that had a clubhouse. Figured maybe they were drinking coffee at the clubhouse. They weren't there. She started calling around all the hospitals. She called the police. She called everybody. Nowhere to be found. It wasn't until the third day that she stops by there. There's a note on the door from this April Parks, who had been appointed the public guardian, that says, in an emergency, call her. So she calls her and finds out what's going on. But this is the most extreme type of a situation, but that's the type of thing that that shows the abuse that can happen. So obviously, pardon me? Pardon me? April Parks. Yeah. So the person. So basically, I mean, what it appears to be the case is that there was public guardians that were going and seeking out people to be public guardian for, which is because it wasn't a nurse, it wasn't the social worker, it wasn't the doctor, it was the person who was going to get appointed, went around looking for people to get appointed to be a public guardian for. So this is an extreme. I've not seen anything quite this extreme in Michigan, and I haven't really seen the abuse directly, but there has to be a check on this, right? This is a loss of rights, and you can read the story. It goes into much greater detail. But the point of this is a real big problem. The governor of Michigan has just appointed a elder abuse task force. And my understanding is this time, there was an elder abuse task force a few years back. This time, the focus is really going to be on guardianship abuse. And so the chair of our section that has the lobbyist and things like that, our chair is going to be on that elder abuse task force. The attorney general is on that elder abuse task force. And hopefully some of these things can be reined in. Because absolutely we need public guardians, but we need to rein in and make sure that there's not self-dealing. All right, the ugly. So when I say ugly, I basically say not necessarily good or bad, just messy. They're not ideal, but it's just messy. So I have a couple of sort of breaking news kinds of things. So currently there's a couple of proposals before the legislature I want you to be aware of, because if they pass, they're going to be something worth that you should probably be aware of, and they seem to be on the fast track. One of them is this social guest law. So I don't know if any of you experienced this. It's a limited situation, but where somebody comes and is staying with an elderly senior, and then in order to get them out, we have to evict them. Okay, you've seen that. Okay, so they're basically looking at passing a law that says, well, if they're a social guest and they've been there less than a month, that you don't have to go through the eviction procedure. And there's going to be some rules and regulations with regard to it, but the idea that you don't just have to evict, you don't have to go through that whole eviction procedure just because somebody came and stayed with you for a few days. The other one that I wanted you to be aware of, and this one can be, on its face, some people might say, oh, that sounds okay, but when you dig into it, maybe it's not so great. So then they're looking at defining a vulnerable adult as over age 65. Yeah, I don't know. That's a little young for vulnerable. And I know, my dad's will be 90 this year, and he's not a vulnerable adult. He's still fully capable. And so to say that you're automatically defined as a vulnerable adult if you're over age 65 is a problem. But then they're going a little further, and they're saying, okay, if there is a transfer of money in excess of $10,000, including over multiple transactions, there's going to be a rebuttable presumption of fraud if it's with somebody over age 65. Yeah, so it's a rebuttable presumption of fraud, and this is just a proposal, it hasn't been passed yet, but a rebuttable presumption of fraud if money is transferred from a vulnerable adult or somebody over age 65 to someone else that they've not known for more than 2 years. and that it can be in multiple transactions. Well, a couple things that we see, I can see the theory behind it is, okay, the prosecutors want to be able to do this without having to prove intent and without have to, that it's difficult to prosecute financial elder abuse, right? So this came from the prosecutors where they're saying, okay, we want to have a clearly defined standard. What I see as a problem is a 65-year-old isn't, sometimes might have a girlfriend, right, or a boyfriend, and they might say, hey, let me help out your son. And if that's a presumption, a rebuttable presumption of fraud, that kind of goes against that whole innocent until proven guilty kind of a thing. So there's some things, I get the idea, this is why it's messy. It's not good or bad, it's just kind of messy. I get the idea behind it, but maybe it's going a little too far. Okay, so what else do we have as far as messy? Promissory notes. So this gets a little bit of a deep dive into the Medicaid issues, but I do want to address this because this is important, and it kind of relates back to that Jensen case where they penalize people for paying for home care. So what happens if somebody comes in and 2 years ago they did give $10,000 away? Or they're going to be penalized because they paid their granddaughter for home care or something like that. How do we fix that? How are we going to fix that? Well, we can get pretty creative. Amy and the rest of us can get pretty creative in trying to say, okay, there's got to be a legal way that we can fix this problem. And they call it curing the penalty. And so the way that we can often cure these types of penalties is the person who received it can sign a promissory note saying they're going to pay it back. Well, they've now proposed a change to the BEMS, the Medicaid rules, that will take effect July 1st. So when I say propose a change, the propose means that it will take effect. They have a comment period where we can comment on it, but once they propose it, it basically takes effect. And it says that you can't do that anymore. You can't do promissory notes unless they were signed at the time the money was transferred. So there's no way to cure something that happened 2 years ago. There's no way to cure something that, like even in a Jensen case where we paid the granddaughter to help us out at home. So that's a problem because first of all, they're creating these penalties that are absurd and abusive penalties, and then they're saying they're trying to get rid of the one way to correct it. In fact, they're attacking these promissory notes all the way around, and when we talk to the Attorney General's office, they say, oh, that's okay, you can still use annuities. Okay, why? If you're saying we can still do the exact same thing and use it as an annuity, what's going on there? Why would they say we have to use an annuity company and have them get some money instead of using promissory notes when you say it has the exact same result, but you're basically forcing us to go to an annuity company to do this? It just doesn't make sense. And it's against federal law. Okay, so it's clearly against federal law, and we're likely, as soon as the law takes effect, we'll probably find a test case and then challenge it in federal court because it is against federal law. The other one that I think is very messy, and if some of you will groan as soon as I say the words, universal caseloads. There you go. If you have anything to do with Medicaid and in certain areas of the state, you will know about universal caseloads. So it is traditionally, when we have a Medicaid application, we submit it and we get a caseworker assigned and we get to call that caseworker and we can email that caseworker and we can have a conversation with that caseworker, and universal caseloads basically says it's going to go into a pool of caseworkers. And each time you have any contact, it might be a different person. So you can never have a conversation. You can never convey what the issues are or ask questions. And what happened with this universal caseload is it basically blew up, and they've acknowledged it. They said, this has slowed down everything. So they were trying to make it speed things up, right? Make it more efficient. It slowed down everything. Slowed it down to the point that they said, okay, we've got this huge backlog now. So instead of getting rid of universal caseload, they said, okay, so we're going to assign some other caseworkers who know long-term care, so non-long-term care caseworkers, to be able to be part of this pool now. So they're just making the pool bigger with people that aren't trained in long-term care. that hasn't solved, surprisingly, that has not solved the problem either. So it is what it is. It's messy. You've got to deal with it. Hopefully they'll realize the error of their ways and they'll switch it back to the other way or find a better way. But right now it is what it is. They've acknowledged the problem. The department has acknowledged the problem and said that there's lots of backlog here. They have not fixed it yet, though. Okay. This is just one of those messy ones, asset verification program. So I talked about this last year, and we've got some experience with this now. What I imagine is they've got this supercomputer that they put your name and number in, a name and social security number in, and then they try to find assets that you've ever owned. And so what happens is when you file a Medicaid application, they go through the whole process right to the point that you're going to get approved, and then they submit it to asset verification. And it's where they're just trying to be Big Brother. Now, I have no problem. I want to get rid of Medicaid fraud, right? I don't want there to be Medicaid fraud. And if there are actual assets, that's great. The couple problems I see with this, that's why I say it's not good or bad, problems I see with this is, number one, is it slows down the process. Because why don't they do this at the beginning and instead of at the end? They've gone through this whole thing, and now at the end, now they're saying, oh, we found these assets. And secondly, every time we've been flagged by this, it's been phantom assets, the assets that didn't occur. They say, well, 2 years ago, we see that you had $100,000 in this account. Yes, and we've been spending $5,000 a month on assisted living. Where do you think that money went? Okay, we've spent it. That was 2 years ago. Or they found money in a special needs trust. Well, that doesn't count. That's exempt. We had a case. It was somebody had, he'd been on Medicaid for 10 years, I think, and his daughter got a hold of us because she didn't know what to do. She just kind of got bounced around in the system. He'd been on Medicaid for 10 years, got denied Medicaid. And it was because they said he had assets that they didn't disclose because of this asset verification program. It turns out that those assets were in a special needs trust that he didn't set up. It was set up by somebody else. He didn't have any access to it, any control over it, never had that money. And it was set up 15 years ago by some relatives or something. Okay? It's clearly exempt under the rules. But the family didn't know what to do. Dad never had any money, so they called us. We decided to step in. Obviously, we did this pro bono. We had to appeal this. They wouldn't negotiate with us. We had to appeal it. We had to take it to a decision before an administrative law judge. We were successful, but at that time, they acknowledged. I said, okay, when we did the cross-examination, I said, okay, so what you're saying is you can deny a Medicaid application because you asked for something and it was impossible for that person that you asked. So they asked for documentation from the man, let's call him Mr. Smith. So they asked for documentation from Mr. Smith, and there was no possible way for Mr. Smith to access that. They said they want a bank statement. Mr. Smith was not on the account, had never been on the account. There was no way he could get that account. And they said, what you're saying is you can deny Medicaid because you asked for something that it's impossible for him to give you, and you're still allowed to deny Medicaid. And they said, yes. So fortunately, the judge disagreed with that and said, no, you can't deny for that. And so we were successful on that. I mean, basically, that's why lawyers. So she asked, how do you fight that? Well, unfortunately, some of that time that's why there's lawyers to get involved. This is really interesting. I talked about this last year, and I was really had a lot of high hopes out for this, the physician's order for scope of treatment. If you notice, when it comes to end-of-life issues, sometimes this gets a little messy because there's not clarity as far as whether or not somebody has a DNR. So even if they have a DNR, if you call the paramedic, what's the paramedic going to do? They're going to resuscitate because that's their job. They're not going to stop and call their lawyer, right? So typically, it doesn't happen every time, but typically, you call a paramedic, paramedic's going to resuscitate. So the idea was to pass this law called Physician's Order for Scope of Treatment that was going to be a standard form that everybody would recognize, and it would have to be signed by a doctor, and that wouldn't work until it was signed by a doctor, and so it's great. And so I've attached a copy of the proposed draft of this form, and the idea is everybody would recognize this form. The emergency folks, the police, the hospital, everybody would recognize it. This has worked very well in several states. They put, and I wrote down the details of this, they put a provision in the Michigan one that says that you have to reaffirm it within a week of any change in place of care, level of care, or change in medical condition. So anytime you go to the doctor, anytime you go to the hospital, anytime you switch where you're living, anytime you switch your level of care, anytime you have to reaffirm it. Well, that almost takes all the teeth out of it. So it's a good idea. Unfortunately, I told you last year to be excited about this because this was going to be something that was going to make it clearer for folks. And it seems like it doesn't have a lot of teeth because it has to be reaffirmed so often. All right, finally, the good. I'm very much excited about this. We've had some success in the courts. So last year we told you about this, that one of the things that's a real great opportunity, when we've got a family, and we've done this so many times where we've got a family where one spouse is the caregiver spouse and the other spouse, it needs 24-hour care, and they get to the point where they need Medicaid, we can go to the local probate judge and say, Judge, here's Sally and Roger, and Sally's been taking care of Roger, and now Roger needs Medicaid, and if we go through the normal process, Sally's going to go broke. Sally's going to be impoverished as a result of this. And there are some protections in the law, you know. Like if you look at what Amy kind of went through and say, okay, there's this much protected. But basically, it's still going to be very difficult for Sally under that circumstance. And the judge can say, all right, well, I'm going to issue a support order saying that some of Roger's assets should be set aside for Sally, and even some of Roger's, or maybe even all of Roger's income can be set aside for Sally, and now we get a zero patient pay amount, and now we get Medicaid, and we don't have to move assets around and things like that. We have to move them to Sally, but we basically can get Medicaid and increase that limit. So Amy said, can't have more than $126,000. We could do it and go in with $300,000 if we get a court order, and the judge says, we're going to assign that $300,000 to Sally, then we can then apply for Medicaid and get approved, and now we have a $300,000 limit instead of a $126,000 limit. It's a great option. The Attorney General attacked that. But the Attorney General lost. So we won, and that was a great decision. It's called the Van Satch and Box case. The court basically acknowledged that that's what Congress intended. This is what is a possible case. Interesting follow-up to that story on the Box case. It went back, and they said, okay, we have to recognize this court order, but when it comes to an income, Mr. Box, they assigned Mr. Box's income to Mrs. Box so that she would have enough money to pay her bills every month. And the DHHS office said, all right, but we don't have to apply that for 1 year. So even though we recognize that we have to honor that court order, we're not going to apply that for 1 year. So for the first year, Mrs. Box is going to have to pay the patient pay amount. So a friend of mine decided to appeal that case. It was appealed to the circuit court. The circuit court said, no, you can't fail to recognize a court order because you say so. And that's pretty much what they said. So those are two really positive cases. This is a really interesting case. So I don't know if you've been around long enough, but a few years ago, it was very common that we would do a specialized trust when we had a married couple. Sometimes they called them spousal annuity trust or SBO, sole benefit trust, but we were able to protect extra assets in a trust for the sole benefit of the healthy spouse. It's been allowed to do that in Michigan for 18 years. That was the way it had been for 18 years. And then all of a sudden, one day in August in 2014, I think it was, the DHHS said, oh, we misinterpreted that law. So people have been doing it for 18 years. There were cases in the system where they had done that, and they said, as of this date certain, August 15th or August 13th or whatever it is, we're going to say you can't do that anymore without changing the law, without giving us notice, without even not applying it to the cases that were already pending. And in the Hagedorn case, they had filed it in January of that year. And because of their delay in processing it, it was now August. So in January, it was perfectly okay to do this. In August, they're saying, well, we were wrong. We've been misinterpreting this law for 18 years. And they were going to now try to apply this new law. It's like driving down the expressway, and you see the 55 sign, and you're driving 50, you see the 75, you see the sign that says you can go 70 miles an hour, and you pass it, and then you see after you pass it that they put up a 55 mile an hour sign, and they say, we're going to give you a ticket. You say, wait a second, it said 70 when I passed it, and they say, it doesn't matter, we made it 55 now, so we're going to give you a ticket. That's basically what they were doing. So we thought all was lost on this. The Court of Appeals agreed with the state. They made it go. They basically said the state can do whatever they want. Michigan Supreme Court took up the case. It was very interesting. I watched the oral argument on it. It was very interesting. They have not made a decision yet. I don't know what their decision's going to be, but it does hold out hope because all of the justices seem to have some concept of why this is an important option and why this is a protection that was actually designed by Congress to make sure we don't impoverish healthy spouses, or what they call the community spouse. I mentioned earlier this Elder Abuse Task Force. I'm really holding hope out that they're going to make some real progress on this. And like I said, I have some close friends that are going to be on the Elder Abuse Task Force, and hopefully we will be addressing some of these things. We are going to Lansing, I don't know, May 21st or something like that, to do some lobbying. I think a group of about 25 lawyers, and we have talking points, we're trying to stay on topic, and the three talking points are dealing with this, the care contract thing, where, penalizing people for staying in their home, and then the income limit on waiver and PACE to try to get around that income limit. So more people would be able to access PACE services and without having to private pay. More people would be able to access waiver services, which most states that have done this have figured out that if you do that, your overall Medicaid budget goes down. So we think we have a very compelling case on both sides of the aisle to say, hey, if we put more money into PACE and more money into waiver, we spend less money as a state, we give people better quality of life, and most other states don't have this, have a way around this income limit. So we're working on that, and then we're also lobbying to increase the budget for waiver and PACE services. So this is back to the theme here, A New Hope. We are here to help, okay? We are... I didn't quite fit in the Kylo Ren outfit, so Kylo Ren's a little short there, but I tried it on, but it was a little snug on me. So I'm not going to tell you who's behind the outfit, but no. So we are here to help. We've gotten to the point where we have the resources in our office where we can help people who are in any kind of situation. I call it pre-crisis. So of course, if they're in crisis, of course they have to make decisions. They got to figure out how they're going to pay for care. Of course we're going to be able to help them. But we've built it up to the point that we have the resources now to be able to help people even if they're not ready for the crisis yet. The crisis hasn't occurred. They're just realizing that in the next few years, mom or dad might need care. At some point in the near future, one of them is going to need to be having some kind of home care, assisted living, nursing home, whatever it is. Our advice is that we start that process sooner than later, and that we set them up so that they know what resources they have, they know what options they have, so that, of course, there's still probably going to be a crisis, right? There's still going to be that fall. There's still going to be that point at which mom doesn't remember dad. But now we're prepared for it, okay? We've prepared the family for that. We've prepared the out-of-town relatives. We're prepared. We're ready to move forward with this. Of people that are not ready, they're not quite ready to look at veterans benefits. They're not quite ready to hire for home care services or to look at assisted living, but they're worried about it, okay? So I call this pre-crisis. And we have a process in our office to be able to help folks with that and make sure that they've got a plan in place. So basically, anytime that there's a family that feels that they are worried about this, they can come into our office and we'll see what we can do for them. And if they agree to hire us, we'll come up with a plan for them. And it'll be a plan in which we can give them options. If they say, absolutely, we're never leaving this house, how many... especially World War II era folks say, I'm never leaving this house. Okay, let's come up with a plan for that. But we're also going to have the backup plans, right? We're going to say, okay, here's the options for never leaving the house. And one of the options is going to be spend money, hire the home health aide, do those types of things. But then we're going to go through and give the options for, okay, but what if this? What if this happens? What if mom doesn't recognize dad anymore? okay? So we'll address that. I want to encourage everybody. I really appreciate that you guys are here. I basically say that you're part of our team now because we do look at it. We always have this silly little theme. This year's was Star Wars. We always have this silly little theme every year. But our own underlying theme every year has been this circle of care. So that circle of care is really an important aspect of this to say, look, we all need each other. There's, each one of us has to kind of pass the folks along. When somebody's at the hospital, they got to be passed on to rehab. When they're leaving rehab, they need to be passed on for home care or assisted living or adult foster care or PACE or whatever it is. And not only are our patients and our clients' lives better when we can work together on that and coordinate that, but also it helps with the business. In other words, if we can set up a situation where we say, okay, if this person goes home to their 83-year-old spouse that's going to try to take care of them, and we don't think the family's going to be around to take care of them 24 hours a day, what's going to happen? They're going to get readmitted. Well, then the hospital's probably going to stop wanting to send people to your direction. And so it's good for business, it's good for our seniors, it's good for each other, it's good for all of those things to make sure that we all work together. And that's been the theme that we've always had. So we basically look at you guys as part of our team now. If you have issues that come up that you think that we can answer a quick question, certainly if you have residents or patients that you think that we'd be able to help, we'd be honored if you would send them our way. I was joking with the team the other day, and I said, I really appreciate how there's so many social workers and other people in the long-term care industry that trust us enough to send us the toughest cases. I really wish you'd send me some easy cases every once in a while. I wouldn't mind that at all, but go ahead and send us the tough cases. But we really can help even the regular family. We've got mom and dad, they've got $100,000. We got mom and dad, they got $300,000. We can help them, okay? And so it's something. And honestly, if we've got mom and dad and they've got $30,000, we can help them. It's not, if there's any, it doesn't have to be. A lot of people say, the feedback I get sometimes is, well, what do we do with people that don't have the resources to pay a lawyer? Almost always, the cost of paying me is going to result in them having more resources, having more options. It usually, almost always, costs less to hire me than any other option. Even though I'm not cheap, I'm not going to say that we're inexpensive here. We can be very expensive, but almost always it's going to be, if they don't get these legal services, they'll be in a worse financial position without it than with it. Okay, so even people that are very low income, yeah. Yeah, so one of the things is on the intake, so usually, sometimes we can waive it because of the circumstances or whatever, but usually they have to come up with at least $350. So most families can come up with $350. But if they can't, we can talk about it or find them other resources. I know Seth's here from Legal Services. Seth and Pam are fantastic over at Legal Services. And so if they have no resources at all, they probably don't need me, because they don't need, if they don't have a house, they don't have these other things. If they have a house, Seth can help them with Ladybird deed, things like that. But the problem is people are not that cut and dry. They're not that black and white, right? It tends to be where they have assets, but they also commingle their assets with their child, or they gave money away to their daughter, or there's messy things. And that's why I say even if they don't seem to have anything, sometimes we have to look at it, because maybe the reason why they don't have anything is because they just put $20,000 in their daughter's name, and they thought that was okay. And they tell you they don't have anything. So it's one of those things that, yeah, they probably have to come up with $350, but that's sort of the starting point to say, okay, we can look at seeing if there solves problems. And almost a good, very large portion of the time, once we sit down with them and start going through their documents, we find out, but there is this life insurance policy that has a $20,000 cash value to it. Well, they're going to get denied Medicaid over that, okay? Or they have an annuity, or they have savings bonds, or they have cash stored up in their house, or they have whatever. And those are the things that we sort of seek out. We root out and say, okay, this is what you need to do with this. This is how we need to fix that. So I do want to make sure that you understand that we would love to help you personally with your individual situation, with your parents, anything like that. And of course, we're honored whenever you can send us your people that you work with. So thank you very much.